5 Italian divers died inside a deep Maldives cave. A rescue diver also lost his life during the recovery effort. But now the question is no longer only what happened underwater. The question is, who was legally responsible before the dive ever began? Because this tragedy did not end when the bodies were recovered. It moved into another dangerous place: courtrooms, regulators, insurance claims, corporate liability, and possible criminal negligence. The safari vessel MV Duke of York was not just the boat that carried the divers. It may now become the center of the legal storm. Its operators face questions from more than one direction. Maldivian authorities are asking whether local diving laws were broken. Italian prosecutors are investigating culpable homicide. Victims' families may pursue wrongful death claims. Insurers may look for reasons to deny coverage. And the operator's defense appears to be simple. We only authorized a normal 30-meter recreational dive. The divers went rogue. So today, we are breaking down the legal liability bombshell surrounding the MV Duke of York. Not to convict anyone, not to accuse before the courts decide, but to understand why this case could become financially devastating for the people and companies connected to that boat. Because if prosecutors prove that the operators knew, allowed, ignored, or failed to prevent an illegal deep cave dive, then this becomes more than a diving tragedy. It becomes a legal disaster. Section 1. The criminal question. The first legal danger is the most serious: culpable homicide. That does not automatically mean murder. It does not mean prosecutors are saying someone intentionally killed the divers. It means investigators are asking whether deaths occurred because of negligence, carelessness, failure to follow safety rules, or failure to stop a known danger. And that question matters deeply here. 5 Italian nationals died while diving from the MV Duke of York. Because the victims were Italian, Rome prosecutors reportedly opened a criminal inquiry. That creates a parallel legal track. One investigation in the Maldives, one investigation in Italy. And that matters because the events happened overseas. But the victims were Italian citizens. So Italian authorities have a strong interest in asking who organized the dive, who briefed the divers, who knew the planned depth, who knew the cave was involved, who was responsible for stopping an illegal or unsafe dive, and who, if anyone, failed to act. That is the key question: failure to act. Because in a case like this, legal responsibility may not depend only on who physically entered the cave. It may depend on who had the duty to prevent the dive from happening in the first place. A boat operator may argue, "We did not go underwater. We did not force them into the cave. We did not make the final decision." But prosecutors may ask a different question. Did the operator have a duty of care? Did the crew know the dive site? Did they know the depth? Did they know the legal recreational limit? Did they know the divers were preparing for something beyond a standard recreational dive? And if they knew, did they do enough to stop it? That is where this case becomes dangerous. Because criminal negligence is often not about one dramatic act. It is about a chain of omissions. A warning not given, a rule not enforced, a permit not checked, a dive plan not stopped, a safety limit treated like a suggestion. And once people die, those small failures can become enormous in court. Now let's talk about the rule that sits at the center of this case. The Maldives has a strict recreational diving limit of 30 meters. That is about 98 feet. The fatal cave dive reportedly went much deeper, around 50 to 60 meters. That is not a small difference. That is not a minor violation. That is almost double the recreational limit. And from a legal standpoint, that matters, because the law gives investigators a very clear line. 30 meters is allowed for recreational diving. 60 meters is not. So the question becomes, how did a dive from a commercial safari vessel end up inside a cave, at a depth far beyond the recreational limit? That question is devastating because it does not require complicated science to understand. You do not need to explain gas density. You do not need to explain narcosis. You do not need to explain decompression theory. A judge, regulator, or jury can understand one simple point. The legal limit was 30 meters. The divers reportedly went far beyond that. So who was supposed to prevent that? That is where the operator's liability risk grows. If the vessel was running a diving operation, then the operator may be expected to know the local diving rules. This is why regulatory violations matter so much. A criminal case may be hard to prove, but a regulatory breach can be much simpler. Did the vessel have the correct permits? Was the license valid? Was the activity authorized? Was the dive within legal limits? Were the proper safety standards followed? If the answer to any of those is no, the operator's defense becomes much harder. One of the most damaging reported issues is the permit question. Reports have said the MV Duke of York did not have the mandatory dive school permit required to run diving expeditions under Maldivian law. If that is confirmed, this becomes a major problem, because now the issue is not only the depth of the dive, it is whether the vessel was properly authorized to conduct that kind of diving activity at all. That matters for three reasons. First, it creates regulatory exposure. The government can suspend licenses, impose fines, or revoke permission to operate. Second, it creates civil liability exposure. If the boat was not properly permitted, victims' families may argue that the entire operation was unsafe or unauthorized from the beginning. Third, it creates insurance exposure, and that may be the most financially dangerous part of all, because insurance companies do not like unauthorized activity. They do not like missing permits. They do not like illegal operations. They do not like policy violations. If the activity was outside the scope of the vessel's license, an insurer may argue, "We do not cover this." That is where a tragedy becomes a financial earthquake, because without insurance, the company and possibly the owners could face claims directly, and wrongful death claims involving 5 foreign nationals can reach massive numbers. Medical costs, recovery costs, repatriation, loss of income, emotional damages, legal fees, government penalties, business interruption, reputation collapse. The permit issue is not a technicality. It may be the hinge that determines whether the operator is protected by insurance or exposed to financial ruin. After the tragedy, the Maldives Ministry of Tourism suspended the Duke of York's operating license. That is not a final conviction. It does not prove guilt, but it is a serious regulatory action. It means the government saw enough concern to stop the vessel from operating while the investigation continues. And for a commercial safari vessel, that is devastating, because a boat like this does not make money sitting idle. Every canceled booking hurts. Every lost charter hurts. Every refund hurts. Every travel agent who stops recommending the vessel hurts. Every future customer who Googles the name and sees fatal dive tragedy hurts. This is how liability spreads beyond the courtroom. The criminal investigation is one problem. The civil claims are another. But the business damage begins immediately. A suspended license can freeze revenue. A damaged reputation can destroy demand. A pending investigation can scare away partners. And once insurers, regulators, prosecutors, and families all start asking questions, the cost of defense alone can become enormous. This is why the words indefinite suspension are so serious. Indefinite does not mean forever, but it does mean there is no quick return to normal. The boat cannot simply move on as if nothing happened. The operator is now trapped in a different kind of cave. A legal cave, a regulatory cave, a financial cave, and the exit may not be easy to find. Now we get to the civil side. This is where the victims' families may seek money damages. Civil liability is different from criminal liability. In a criminal case, prosecutors must prove a crime. In a civil case, families may argue negligence. They may say the operator failed to use reasonable care. And in this case, the duty of care question may be central. A commercial dive operator is not just a taxi service. It is not just a boat ride. When you take paying divers to a dive site, you are expected to operate within the law. You are expected to provide safe briefings. You are expected to know the limits. You are expected to stop unsafe conduct when you have authority to do so. You are expected to match the dive to the divers, the conditions, and the equipment. That does not mean the operator is automatically responsible for every bad decision a diver makes. Divers are responsible too, especially experienced divers, especially professional level divers. But the operator still has responsibilities, and the civil case will likely focus on where those responsibilities began and ended. Did the boat only transport the group, or did it organize the dive? Did the crew know the intended depth? Did the guide or dive director know the cave plan? Were the divers told clearly that 30 meters was the maximum? Was that limit enforced? Were there any signs that the group planned to exceed it? Was the equipment appropriate for the depth? Was there emergency support? Was there a written plan? Was there a record of the briefing? Those questions matter because civil liability is often built from documents, logs, briefings, waivers, dive plans, messages, permits, crew statements, computer data, GoPro footage. The family's lawyers will not only ask what happened underwater, they will ask what happened before the divers entered the water, because that is where duty of care lives. Another major issue is equipment. The vessel reportedly had standard air and nitrox 28 available, but a 50 to 60 meter cave environment is not a normal recreational dive. At those depths, many technical divers would be thinking about different gas planning, redundancy, decompression strategy, and possibly helium-based mixtures such as trimix. Now, this does not automatically mean the boat had a legal duty to provide trimix. That depends on the operation, the permit, the advertised activity, the local regulations, and what was actually planned. But it does raise a dangerous question. If the operator only had recreational gas and recreational support, why did the dive reach technical depth? That question cuts both ways. The operator may say, "Exactly. We were only supporting a recreational dive. We did not authorize 60 meters. But the families may ask, then how did a dive from your vessel end up at 60 meters inside a cave? That is the trap. The same fact can become both a defense and an accusation. The operator says, "We were not equipped for a technical dive, so we clearly did not approve one." The plaintiffs may say, "You were not equipped for a technical dive, but you allowed circumstances where one happened anyway." That is why this case is so legally dangerous. Every fact has two edges. Now we need to be fair. The operator has a defense, and it may be a strong one depending on the evidence. The defense appears to be this: the vessel was hired for a standard recreational dive. The divers were briefed on the 30-meter limit. The crew did not authorize a deep cave penetration. The divers were experienced adults. They knowingly violated the rules. They went rogue. If that defense holds, it could shift major responsibility away from the operator. Because a boat operator cannot physically control every movement a diver makes underwater. Once divers descend, they make choices. They control their depth. They control their direction. They control whether they follow the plan. And in this case, some of the divers were reportedly very experienced. That matters. A court may ask, should these divers have known better? Should professional level divers understand the danger of 60 meters on inappropriate gas and equipment? Should they have refused the dive? Should they have turned around? Should they have stayed within the legal limit regardless of what anyone else did? Those are real questions, and they matter legally. Because if the divers willfully violated a clear briefing, that can reduce or shift liability. But there is a problem. A defense is only as strong as the evidence behind it. If the operator says there was a 30-meter briefing, investigators will ask, where is the record? Who gave it? Who heard it? Was it written? Was it signed? Did the dive guide enforce it? Did anyone object? Was the cave discussed? Was the site known to exceed 30 meters? Were dive computers checked? Were depth limits logged? Were there previous dives like this? If the paper trail is weak, the defense becomes weaker. If the evidence shows the operator knew the dive would go deeper, the defense may collapse. That is why the investigation matters so much. This case may turn on what people said before the dive. Not after. Before. Many dive operators rely on waivers. A waiver says the diver understands the risks. A waiver says diving can be dangerous. A waiver says the diver accepts responsibility. But a waiver is not a magic shield. A waiver does not usually protect an operator from gross negligence. A waiver does not excuse illegal activity. A waiver does not erase missing permits. A waiver does not allow a business to ignore safety laws. So if the operator's defense depends heavily on recreational waivers, investigators and lawyers will ask, what exactly did the waiver cover? Did it cover recreational diving only? Did it mention caves? Did it mention depth limits? Did it mention decompression risk? Did it mention technical diving? Did the divers sign it? Was it in a language they understood? Was it connected to this specific dive? And most importantly, can a waiver protect an operator if the activity itself was not properly permitted? That is the big one. Because if the permit problem is real, a waiver may not save the operator. You cannot always waive your way out of regulatory violations. And you cannot always contract your way around a duty of care. That is why this case is not only about whether the divers accepted risk. It is about whether the operator created, allowed, or failed to prevent an unauthorized risk. Now let's talk about the part that could financially destroy the operators: insurance. Most people think lawsuits are the biggest danger, but the real danger is losing insurance coverage. A commercial vessel usually needs insurance for liability. That insurance is supposed to protect the owner and company if something terrible happens. But insurance policies have exclusions. They have conditions. They have warranties. They have rules. And if the insured party violates those rules, the insurer may deny coverage. That is why the permit issue matters so much. If the vessel did not have the required authorization for dive operations, an insurer may argue that the activity was outside the policy. If the dive exceeded legal limits, the insurer may argue that the claim involved illegal or unauthorized conduct. If the boat was not licensed properly, the insurer may argue that coverage is void. If the operation misrepresented its activities, the insurer may argue material non-disclosure. Now, to be clear, we do not know what the policy says. We do not know whether coverage will be denied. We do not know what exclusions apply. But from a risk perspective, this is one of the most dangerous parts of the case. Because if insurance stays in place, the insurer may pay defense costs and settlements. If insurance collapses, the company may be fighting alone. And if the company cannot pay, plaintiffs may look for other ways to recover. Corporate assets, owner involvement, management decisions, other related entities, personal guarantees. Piercing the corporate veil is not easy. But in a catastrophic case, lawyers may look everywhere. That is why this could become financial ruin. Not because guilt has already been proven, but because the combination of deaths, permit questions, suspended license, foreign victims, and possible insurance exclusions creates enormous financial exposure. This case is also complicated because it crosses borders. The boat was operating in the Maldives. The victims were Italian. The company may be Maldivian or locally connected. The vessel may have international insurance. The tour or expedition may involve foreign organizers. The equipment may be investigated in Italy. The bodies were repatriated. Autopsies may be handled by Italian authorities. That creates a multi-jurisdiction trap. Different countries, different laws, different standards, different prosecutors, different civil procedures, different insurance rules, and potentially different defendants. This matters because nobody can simply say, the accident happened in the Maldives, so only Maldives law matters. That may not be true. Italy has an interest because its citizens died. The Maldives has an interest because the incident happened in its waters and involved its tourism and diving regulations. Insurers may have their own governing law under the policy. Families may look for the most effective place to file claims, and each forum may produce different pressure. Maldives regulators may focus on permits and tourism law. Italian prosecutors may focus on culpable homicide. Civil lawyers may focus on negligence and damages. Insurers may focus on exclusions. That is how one tragedy becomes 5 legal battles at once. So who could face scrutiny? Potentially several groups. The vessel operator, the company operating the cruise, the owner or ownership entity, the dive director, the instructor or guide connected to the dive, any organizer who planned or advertised the expedition, any person who briefed or approved the dive plan, any entity that represented the activity as safe or authorized. Now that does not mean all of them are guilty. It does not mean all of them will be charged. It means investigators will look at the chain of responsibility. Who had authority? Who had knowledge? Who had the ability to stop the dive? Who benefited commercially? Who controlled the vessel? Who controlled the diving operation? That is the key word. Control. Legal responsibility often follows control. If you controlled the operation, you may carry responsibility. If you knew the risk and failed to act, you may carry responsibility. If you had no knowledge and no control, your defense may be stronger. That is why the operator's claim that the divers went beyond the plan is so important. It is a fight over control. Were the divers acting independently, or were they operating under the boat's dive system? That question may decide everything. The most important evidence may not be dramatic. It may not be the GoPro. It may not be the cave map. It may be paperwork, the dive briefing, the vessel permit, the dive logs, the passenger waivers, the operator license, the messages between crew and divers, the itinerary, the gas logs, the dive computer data, the statements from the survivor, the statements from other guests on board, the records showing what the Duke of York was authorized to do, and the records showing what the divers were told before entering the water. That is what lawyers will look for, because once the emotion fades, cases are built from evidence. If the paperwork shows a normal recreational dive, and the divers secretly violated the plan, the operator's defense improves. If the paperwork is missing, vague, or contradicted by witnesses, the operator's risk increases. If evidence shows the crew knew the actual plan involved the cave or deeper depths, the legal exposure becomes severe. And if evidence shows the vessel lacked required permits, the operator may face regulatory and insurance consequences regardless of what happened underwater. Even without a conviction, this case could destroy the business side. A suspended license stops operations. A criminal investigation scares customers. Civil claims drain resources. Insurance disputes create uncertainty. Legal fees pile up. International media damages the brand. Travel partners may cut ties. Future guests may avoid the vessel. And if the license is permanently revoked, the business model may collapse. This is the reality of commercial tourism accidents. The legal process may take months or years, but the financial damage begins immediately. And in a tourism-dependent industry, trust is everything. Once a boat becomes associated with the deaths of 5 guests and a rescue diver, rebuilding trust may be nearly impossible. That is why this case is so serious for the Duke of York operators. They are not only fighting allegations, they are fighting the collapse of confidence. So what is the core legal question? It is this. Was this an unauthorized rogue dive by experienced divers who violated a clear recreational briefing? Or was this a preventable tragedy enabled by an operator that lacked the right permits, failed to enforce the rules, and allowed a dangerous dive to happen? That is the battle. Everything else flows from that. If it was a rogue dive, liability may shift heavily toward the divers themselves. If it was a preventable operator failure, liability may shift toward the boat, company, crew, and organizers. If it was a mixture of both, the courts may divide responsibility, and that may be the most realistic outcome. In many tragedies, responsibility is not clean. It is shared. The divers may have made fatal decisions. The operator may have failed to enforce safety limits. The guide may have failed to stop the plan. The company may have lacked proper authorization. The system may have allowed too much confidence and too little control. That is what investigators now have to untangle. Conclusion. The Maldives cave tragedy is no longer only a diving story. It is now a legal story, a business story, a regulatory story, an insurance story, and possibly a criminal negligence story. The MV Duke of York operators face a dangerous question. Did they simply transport experienced divers who broke the rules? Or did they operate a diving activity that should never have happened? That answer could decide whether this ends as a tragic accident or a case of criminal culpability and financial ruin. And here is the lesson for every dive operator, every guide, and every diver watching this. Rules are not decorations. Depth limits are not suggestions. Permits are not paperwork for later. And waivers are not magic shields. Because when everything goes wrong underwater, every decision made before the dive comes back to the surface. The briefing, the permit, the license, the gas, the plan, the authority, the warning, the stop that should have happened before anyone entered the water. 5 divers died in that cave. A rescuer died trying to recover them. Now the courts and investigators will decide who, if anyone, should have stopped the chain before it reached 60 meters. And if the answer points back to the operators, the legal damage may be only the beginning. Because once insurance walks away, once regulators shut the vessel down, once families file claims, and once prosecutors start asking who had the duty to say no, the real cost of the dive may be counted not only in lives lost, but in everything that collapses afterward. Respect the ocean, respect the law, and never forget, a dive can be over before it starts. But liability begins before the first diver even hits the water.